This is the case of Tropical Hot Employees UNION-CGW versus Tropical Hot Food Market Incorporated. The petitioners of this case was the Tropical Hot Employees UNION-CGW, and for the respondents is the Tropical Hot Food Market Incorporated. Facts of the case. January 2, 1968, the rank-and-file members of the Tropical Hot Food Market Incorporated formed a local union named the Tropical Hot Employees Union and elected their officers, ratified their constitutions and bylaws, and immediately sought affiliation with the National Association of Trade of Unions or NATU. January 3, 1968, the National Association of Trade Unions approved the application for affiliation of the Tropical Hot Employees Union. Following such association with the National Association of Trade Unions, the registration certificate number 5544 IP was issued by the Department of Labor on behalf of the Tropical Hot Workers Union and the National Association of Trade Unions. However, it seems that the National Association of Trade Unions itself, as a labor federation, was not registered with the Department of Labor. Collective bargaining agreement was concluded between the parties on April 1, 1968, the term of which expired on March 31, 1971. Section 1. The company acknowledges the union as the sole and exclusive collective bargaining agency representing all its employers and staff on all matters pertaining to salaries, hours of work, and other terms and conditions of employment. Section 2. Employees who are already members of the union at the time of the signing of this agreement, or who become members of the union thereafter, shall be expected to remain in the union as a condition of continued employment. Section 3. Any employee who is expelled from the union for joining another federation or for establishing another union, or who fails or refuses to remain a member of the union as required, the company shall be discharged at the written order of the union. On May 21, 1971, the respondent company and the Tropical Hot Employee Union and the National Association of Trade of Union entered into a new collective bargaining agreement which ended on March 31, 1974. This new collective bargaining agreement incorporated the previous union shop security clause and the attached check-off authorization form. The National Association of Trade Union received a letter dated December 15, 1973, jointly signed by the incumbent officers of the local union, informing the National Association of Trade Union that the Tropical Hot Employee Union was disaffiliating from the National Association of Trade Union Federation. Secretary of the Tropical Hot Employee Union, Nemesio Barro, made an announcement in an open letter to the general membership of the Tropical Hot Employee Union concerning the latter's disaffiliation from the National Association of Trade Union and its affiliation with the Confederation of General Workers. The letter was passed around among the members of the Tropical Hot Employee Union and the National Association of Trade Union, to which around 137 signatures appeared as having given their consent and acknowledgement of the decision to disaffiliate the Tropical Hot Employee Union from the National Association of Trade Union. The then so-called Tropical Hot Employee Union-CGW held its annual election of officers with Jose Encinas elected as president. On January 3, 1974, Encinas, in his capacity as the Tropical Hot Employee Union president, informed the respondent company of the results of the elections. On January 9, 1974, Pacifico Rizal, president of the Confederation of General Workers, wrote a letter in behalf of the complainant, Tropical Hot Employee Union-CGW, to the respondent company demanding the remittance of the union dues collected by the Tropical Hot Food Mart, incorporated to the Tropical Hot Employee Union-CGW, but this was refused by the respondent company. A proposal to the respondent company by the National Association of Trade Union Federation to fire him, Encinas, as a result of his breach of Article No. 3 of the Section 3 of the Collective Bargaining Agreement. In order to dismiss the other officers and members of the Tropical Hot Employee Union-CGW, the respondent company demanded approval from the Secretary of Labor. Case number NLRC LR2521 was filed against private respondents for unfair labor practices by the Tropical Hot Employee Union-CGW and individual complainants. The employees were requested by the Tropical Hot Employee Union-CGW to affirm their membership. Some were not told that they would be fired under the collective bargaining agreement. At the order of DILAG, the President General Manager of the respondent organization suspended 24 employees on March 5, 1974, another 37 on March 8, 1974, and 2 more on March 11, 1974, pending the Secretary of Labor's acceptance of the dismissal request. Labor Arbiter Daniel Lucas issued an order dated March 21, 1974, holding that with the issuance of the NLRC order dated February 25, 1974, in NLRC case number LR2670, the problems posed by the parties became moot and academic, which guided the holding between the Tropical Hot Employee Union and the National Association of Trade Union and the CGW of a certification election among the rank and file employees of the requested organization. He also ordered the reinstatement of all the complainants, that the respondent corporation cease and refrain from any further actions of dismissal without prior order from the NLRC, and that the plaintiff, Tropical Hot Workers Union CGW, file case-by-case representation cases within the time of freedom provided for between the parties by the current collective bargaining agreement. The decision was overturned by the NLRC. The Secretary of Labor released a decision affirming the Commission's conclusion. Issue of the case. The issues of the related case are the following. Number 1. Whether or not the petitioners failed to exhaust administrative remedies when the case was immediately elevated to the court without an appeal having been made to the office of the President. Number 2. Whether or not the disaffiliation of the local union from the National Federation was valid. And Number 3. Whether or not the dismissal of petitioner employees resulting from the union's disaffiliation for the mother federation was illegal and constituted as unfair labor practice on the part of the respondent company and federation. The ruling of the Supreme Court. Number 1. The remedy of appeal from the Secretary of Labor to the Office of the President is not a mandatory requirement before resort to courts can be had, but an optional relief provided by law to parties seeking expeditious disposition of their labor disputes. Failure to avail of such relief shall not in any way serve as an impediment to judicial intervention. And where the issue is lack of power or arbitrary or improvident exercise thereof, decisions of the Secretary of Labor may be questioned in a certiorari proceeding without prior appeal to the President. Number 2. The Tropical Hot Employee Union is a separate and voluntary association. Therefore, as a local union, it has the right to disaffiliate from the mother federation. Local union has a fundamental right to freedom of association, means employees in a union can freely join, assist, or leave from the group on their own interests or choosing. Under the Section 3 of the Republic Act No. 875, Employees' right to self-organization. Employees shall have the right to self-organization and to form, join, or assist labor organizations of their own choosing for the purpose of collective bargaining through representatives of their own choosing, and to engage in concerted activities for the purpose of collective bargaining and other mutual aid or protection. Even though the Tropical Hot Employee Union is affiliated with the National Association of Trade Union in the registration with the Department of Labor, does not mean that the Tropical Hot Employee Union or the local union is dependent from the federation. The Tropical Hot Employee Union also owes the federation from its creation and continuous existence to the will of its members. When the local union withdrew from its former union, it was merely exercising the right to labor organization for the effective enhancement and protection of the interests of its members. There is nothing in the Constitution and bylaws of the National Association of Trade Union and Tropical Hot Employees Union that prohibits the local union to disaffiliate from the federation. Also, the National Association of Trade Union was not even a legitimate labor organization. The National Association of Trade Union appeared to be was not registered with the Department of Labor and Employment. Number 3. It is clearly stated that the Tropical Hot Employee Union disaffiliated from its mother federation, the National Association of Trade Union, but didn't lose its personality as the sole bargaining union under the collective bargaining agreement with the Tropical Hot Food Market Incorporated. and the security clause within their agreement cannot be used against the petitioners in their dismissal because it is not applicable to the circumstances in this case. It is also stated in their collective bargaining agreement that it is only applicable to dismiss an employee if the employee who is expelled from the union for joining another federation or forming another union, or who fails or refuses to maintain his membership therein as required, shall, upon written request of the union, be discharged by the company. There were no employees, but the wool union, the tropical hat employee union, applied withdrawal from the federation. It is clearly stated that there are no violations happened between the collective bargaining agreement of the Tropical Hat Employee Union and the National Association of Trade Union. Thus, there is no concrete grounds to terminate or dismiss the employment of the petitioners. And so ordered.